good to see you all today and good to see some friends as well. The objectives of today's session is really to provide an overview of procurement and subsidy law developments in the last year. There's been a lot happening. We've just had the first court case on the Subsidy Control Act, and there have been a number of significant procurement decisions, and obviously we're waiting for the implementation of the Procurement Act in October next year. So in terms of what I'm going to talk about on the next slide, please, Romany, I'm going to look back and talk about the Subsidy Control Act 2022 and what can you learn as local government lawyers from the last 9 months, and then I was proposing to talk about some of the procurement cases that are of interest, and then look forward to the Procurement Act, where we are now and how to get ready for the Act. It would be interesting just in terms of understanding you as the audience and the level of specialisms in procurement and subsidy control. Are you able just to put something in the chat briefly about what sort of level you're at? Because I'm just wondering whether there's quite a lot to get through in the session, and whether I skip over the review of procurement cases and then sort of concentrate on Subsidy Control Act procurement looking forward. But I can talk about some of the key cases on frameworks, but I'd just be interested to get your feedback on that. Okay, all right. I'm not sure that anybody's put anything in the chat, so I'll carry on and see how we go. So on the next slide, please. The next slide talks about it provides an overview of the Subsidy Control Act 2022. So this came in force on the 4th of January at the beginning of the year, and it replaces the interim subsidy control regime, which was the Trade and Cooperation Agreement. It provides a much more permissive and flexible approach to subsidy control. So unlike the old EU state aid regime, where subsidies were generally prohibited, the Subsidy Control Act permits a much wider range of subsidies. There are some subsidies which are automatically prohibited, which you have to watch out for. For example, these normally relate to unlimited guarantees or guarantees relating to import and export, and where there are restructuring subsidies or relocation subsidies, they need to be looked at very carefully. We're going to look at the definition of a subsidy in a minute, but whilst a lot of the terminology has changed, some of the principles still are very much the same as under state aid law. One of the big changes that has taken place is that it's now the responsibility of the public authority giving a subsidy to carry out the subsidy control assessment. Now, in practice, while that has always been the case, what has actually happened is that the responsibility has often been flowed down to the beneficiary of the subsidy. And the consequences of a subsidy are that the beneficiary can be affected because of the risk that a subsidy could be required to be clawed back. But the the case law and the comments coming from the enforcement bodies is very much placing the responsibility on the public authority to carry it out. And I appreciate that that provides quite a challenge for local authorities who may not necessarily have the specialist expertise and or resources to carry out these types of assessments. So the next slide sets out the process that needs to be followed if you think that you might have got a subsidy situation. The first step is to consider whether you have got a subsidy in the first place, and we're going to look at the definition and what constitutes a subsidy. If you find that you do have a subsidy, then the next questions to consider are who the beneficiaries are and whether you can take advantage of the frameworks that allow you to award the subsidy without going into too much of an assessment. So de minimis, which allows beneficiaries to receive a certain amount of aid over a 3-year period, has been replaced with the concept of minimum financial assistance. And the amount of aid that a beneficiary can receive is been increased to 315,000. And then some of the services that local authorities may provide, for example, in relation to transport or some other types of services, may be services of public economic interest. And there was a similar concept under the old state aid laws. There are also 3 streamlined schemes which work in a similar way to the block exemption, in that if you can fit your subsidy within the terms of the streamlined schemes, then you don't have to carry out any further assessment as to compatibility. However, the streamlined schemes, although they operate in a similar way to block exemptions, are very different, and the values that can be permitted are significantly lower, and the streamlined schemes are very tightly scoped. There is a streamlined scheme which is called Levelling Up, but actually it doesn't really cover levelling up in the way that we would necessarily think of it as meaning. It's more to do with training, subsidies for training purposes. The other streamlined schemes relate to energy investments and research and development, so less likely to be applicable to local authorities. If you can't structure your subsidy within any of those easy wins, then it's necessary to carry out a compatibility assessment against 7 principles which are set out in the Subsidy Control Act. And depending upon the amount of subsidy, this can be quite a detailed exercise. Now, where subsidies are granted cumulatively or for an individual subsidy for more than £10 million, it's likely that that will trigger a mandatory referral to the Subsidy Advice Unit. So what that means is that the public authority has to carry out a compatibility assessment against the principles, together with information about the nature of the subsidy and any evidence, and make a mandatory referral to the Subsidy Advice Unit, who will carry out a report into that. And we're going to look at one of the reports that has been carried out in relation to a local authority subsidy. The other change that has been brought about it with the Act is about publication. So similarly with the theme of transparency under the Procurement Act, there is a much greater focus on publicising subsidies so that the information is available and aggrieved parties can apply for further information or seek judicial review if they want to challenge a subsidy. So as a general rule, any standalone subsidy has to be published, and other subsidies, for example, if you're using a streamlined scheme, the relevant threshold is over £100,000. So going on to the next slide, I've set out the 4 conditions that are required to constitute a subsidy. So for those of you that were familiar with the old EU state aid rules, they'll be familiar, but as I say, it's different language. So you must have all of those conditions to be met in order to have a subsidy. The first is that a measure must be given directly or indirectly from public resources. It must confer an economic advantage, and importantly, specifically favour an enterprise. So that means that we're going to look at a case law on this, is that the beneficiary must be carrying out some kind of commercial activities in order to be treated as an enterprise, and there must be an actual or potential impact upon competition or investment, either within the UK or between the UK and a country outside of the UK. And the definition of subsidy has been drafted so that it catches a wide range of measures and grants or guarantees or services of an undervalue remain caught. So just to provide some facts and figures on the next slide about subsidy control. So I mentioned that we've had the first case in the Competition Appeal Tribunal, which we're going to have a look at. There have been 13 mandatory referrals to the Subsidy Advice Unit to date and 12 reports. Now, I attended a recent subsidy control briefing by the Subsidy Advice Unit, and they said that they had expected some voluntary notifications to be made. There is a possibility of doing a voluntary notification, but none have been received to date. So in terms of the main players with subsidy control, the Competition Appeal Tribunal is the only enforcement body in the UK, and complaints are made by way of judicial review. There's a very tight timescale for bringing judicial review complaints. The Subsidy Advice Unit, it has 2 roles: to provide non-binding advice to public authorities on subsidies and to monitor and report on the new regime. Now, because it's not independent under the withdrawal agreement and cooperation agreement, it can't actually be an enforcement body. And the Subsidy Advice Unit has a fairly difficult role in providing non-binding advice, but providing a steer on the new Act. So there is a way of looking at all the subsidies that have been published on the subsidy database. Unfortunately, it's not that easy to search. So I tried to do a search to see how many subsidies had been published by local authorities, but I was unable to find that information. But there are quite a lot of subsidies out there from a number of local authorities, and I'd be very interested in finding out from you whether you've had any subsidies that you've had to think about notifying. So let's go on to the first case, which is on the next slide, which is it's actually a challenge brought against Durham County Council, so a local authority case under judicial review, and it was a complaint brought by a waste company. So there's a number of waste cases that I'm talking about today. The council was cross-subsidising the collection of commercial waste. So, Durham County Council had the responsibility.
Sorry, Stephanie, can you just bring your microphone up, please?
Apologies, sorry. So Durham County Council had the responsibility as the local authority for collecting both commercial and household waste. Now, it carried out the collection of waste itself using its own vehicles, and then it outsourced the actual disposal of the waste to a third party. Now, the council collected household waste and commercial waste using these same vehicles. And the complainant said, well, hang on a minute, there's a possibility that by doing this, you're actually subsidizing your commercial function. The way that commercial waste providers were charged was they had to pay, they had a charge which was based upon the cost of the staff involved, but it was also based upon the actual number of bins that were collected and the frequency of the bin collection. And the council said, well, we've tried our best to apportion costs against the household and commercial waste streams. Now, what did the Competition Appeal Tribunal say? Next slide, please, Romany. They looked at the definition of a subsidy under the Act and they considered whether the constituent elements were met. And in fact, on their reading, they found that there was no subsidy on the basis that there was no measure which affected an enterprise. So they said that the functions of the county council were all public. That although the authority collecting the commercial waste, it was acting under its health and environmental powers, and therefore it wasn't carrying out a commercial activity. They also looked to see whether there was any specific financial advantage. And they said, well, if there was a specific financial advantage, it actually was that any efficiencies of scale in collecting the waste this way were actually passed down for the benefit of the consumers and the commercial providers. And in fact, there wasn't a cross subsidy. So the complaint was unsuccessful. Now, I think there's a number of interesting points to make about this. First is that the analysis about whether an organization is acting as an enterprise departed from the approach that the EU courts have taken. So the EU courts have said, well, you can have a situation where you have a public body, in fact, another type of organization who carries out both public and private activities. But they said, well, they looked at this, but the EU case law was only persuasive and non-binding. And on the facts of the case, they found that the local authority was acting in a totally public way. Now, interestingly, what they said is, actually, had the council set up a subsidiary company to carry out the commercial waste or instructed it in another way, they might have come to a different conclusion. I find that slightly difficult concept because the functions are still the same, no matter how it's being structured. The other point is that under judicial review, the tests are slightly different in that the local authorities have a considerable margin of appreciation as to how you have it apportioned the costs. But it was clear that the Competition Appeal Tribunal said that it was clear that there was a responsibility of the public authority to undertake a subsidy control assessment. And in fact, in this particular instance, it was criticised because it hadn't actually taken a subsidy assessment at the relevant time. Could we go on to the next slide, please? What is also interesting is that there's been quite a lot of hearings and case management discussions about subsidy control, and the Court of Appeal has sent a clear message that it wants the process to be as efficient and fast as possible within the possibilities within the current court system. So my take on the case is that the Competition Appeal are looking to differentiate the UK subsidy control regime from the old regime. They are going to take a different approach. At the moment, that possibly leads to some uncertainty in interpretation for the moment until we've had a few more cases. So if we look then at the work of the Subsidy Advice Unit. Next slide, please. So there have been a number of references to the Subsidy Advice Unit, and they have concerned energy and infrastructure grants, regeneration grants, cultural grants to the English National Opera. There has been a research grant, so a wide range of types of grants and subsidies. The one that I want to look at is Livewire, because it is a local authority, one of the first local authority cases. So it was a mandatory reference by Warrington Borough Council into a proposed subsidy into Livewire, a community interest company. Now, Livewire carried out the library and swimming and leisure functions for Warrington Borough Council. They got into financial difficulties and wanted to make a £8 million restructuring grant to Livewire for the continued provision of leisure services to ensure levelling up and to ensure access to leisure services for its community. Now, although the value of the grant meant that it was below the general threshold for a mandatory referral, because it's a restructuring grant that has a slightly different regime, so it still fell within the requirements to be notified under a subsidy of particular importance. Now, what the Subsidy Advice Unit do is they have a very tight timescale for carrying out the report. And I think they only have 30 days from when they've got the receipt of all the information. And they then publish a report into their findings as to whether the subsidy control is compatible with the principles. We go on to the next slide, please. Now, in this case, they were fairly critical of the approach that was taken by the Borough Council. So there were 7 principles, and they carried out a detailed analysis of each of the principles, looking to see whether there was an explanation of the approach that the Borough Council had taken to each of the principles, and whether they had provided supporting evidence. Now, on the facts of the case, I've talked about the fact that there was a subsidy of more than 8 million. The advice unit said it was unclear exactly how much the proposed subsidy. There was a bundle of subsidies, and for various different things, and they criticised the council for not really explaining in relation to each limb of the subsidies how the principles had applied. And they said that although some attempt had been made to define the market, there wasn't very much market information to support it. They then go on to say it is not the Subsidy Advice Unit determine what wasn't their role to determine what constitutes a subsidy or its value, whether a subsidy can be given, or assess directly whether it complies with the subsidy control requirements. Public authorities are responsible for taking decisions about the subsidies that they make. So what if you're looking at a report, they will say, give guidance as to whether the statutory guidance has been met, but they've been they don't actually give a conclusion. Now, I have some sympathy with the Borough Council in this case, because it was one of the early reports that was made, and the value of the subsidy, it was several millions, but it's not in the realms of tens of millions. And the guidance says that you have to carry out an analysis which is commensurate and proportionate with the value of the subsidy. And when you're listening to the Subsidy Advice Unit guidance on carrying out the subsidy, they say, well, we think that most councils will be able to do it themselves, and it shouldn't need specialist expert advice. But when you're looking at the comments that are made, and not particularly just in live wire, but in some of the other cases, because the Subsidy Advice Unit sits within the Competition and Markets Authority, and they're dealing with looking at complex mergers and competition assessments, they do take a very economic approach, and they are looking for, I think, often economic assessment impacts to support the legal analysis that is being made. So I think it is a challenge if local authorities are going to structure a subsidy within the compatibility assessment, particularly for the high value ones, to carry out this piece of work. Right, could we go to the next slide, please? The other points to make about the reports is that they are published for everybody to see, and there isn't the possibility of the local authority to look at the decision before it's made and to take stock of it, and to make sure that all the information that any confidential information is not provided. So if you are going to consider this, you need to flag up very carefully what information is confidential so that it's not published. And the report obviously can provide grounds for an aggrieved party to challenge. And in fact, once the notification has been made, in this particular case, a competitor of Livewire had made representations to the Subsidy Advice Unit on its thoughts on the proposed subsidy. So I think it is still very early days. There is still a certain amount of uncertainty about how the subsidy control regime is going to be implemented, and very heavy reliance is being placed on the statutory guidance that is being put out there, and I understand it is being quite regularly updated, but it's 200 pages worth of guidance, so quite a lot to get through. That's the end of the section on subsidy control. I was just going to take a brief pause there and ask if anybody had got any questions, or had anybody got any comments to make on subsidy control before I go on to procurement. Okay, all right. So the procurement case law. In-house intelligence versus NHS England is just a point to flag up the need when you are considering how to behave in a procurement process to ensure that you consider the rights of all bidders in a fair and equal manner. This case dealt with an application by a bidder or a complaint by a bidder that it wasn't given the opportunity to submit a tender after the deadline. And what happened in this case was that the bidder tried to upload submissions to various lots in a tender within the last 6 minutes of the deadline. So it had left it to the last minute, and it uploaded the information in the wrong manner, and it was then unable to take away a particular document and file it in the appropriate place. And it complained to the local authority, who sought advice from the platform. They couldn't get it sorted out in time, and the bidder said, well, hang on a minute, it was a platform error. I should have been allowed to upload the information later. The NHS carried out some investigation and said it wasn't a platform error. Really, you should have uploaded it in more time. And the court said it was right, in fact, to not allow the bid to be uploaded, because this would have been unfair to other bidders. Another practical point is simply to make it very clear in your tender documents that it is the responsibility of the bidder to upload the submissions in time. The next case that I want to talk about is a case on frameworks, which I think is really important, because I'm conscious that you're probably using a lot of framework agreements. And this case and some other cases before that have highlighted the need to make sure that frameworks are used properly. Otherwise, there is a risk that they are not valid and can be challenged. And the consequences of a framework which is not properly being called off in accordance with the rules is that it can be one of those grounds for ineffectiveness and fines. So what happened in the Consultant Connect case was that, again, it's an NHS case. They were looking for a provider of IT services, and they carried out what was described as a sort of market engagement and product demo exercise, and invited a couple of parties to engage in discussions and to carry out a product demo, which the claimant did together with another party. But what the claimant wasn't told was that the NHS were actually scoring the product demos and using this information to finalize their requirements before they went out to competition. And they finalized those requirements, taking into account their preferred option, which was for a competitor product to the claimant. And then the NHS said they carried out a mini competition under the framework, but in fact that wasn't quite right because they only invited one party to bid under the mini competition. And it took quite a long time for the claimant to actually find out why it had been unsuccessful. But eventually managed to get disclosure and found out what had happened and brought a challenge. And the court said that actually the NHS had used the framework in a way as to manipulate the framework, and that there had been an improper use of the framework agreement and breaches of transparency and fairness. So the fact that the product demo was scored and the parties weren't told is a breach of fairness and transparency. And then the fact that a mini competition was carried out, but actually it wasn't carried out because only one person was prepared to bid, was an artificial narrowing of competition. And as I say, the remedy for that is contract ineffectiveness. On the facts, the court decided that it was actually more appropriate to change contract ineffectiveness to shortening, which is a possibility, but there were still damages and fines to the NHS. So a number of points to make about frameworks. I put together on the next slide a list of sort of issues to consider when you are using frameworks, because I think it can be that a compliance check isn't always carried out as to whether a framework is the most appropriate route to procurement. The first thing to note is the framework in force? And I have looked at frameworks that clients are proposing to use and found that actually they have already expired and there's a new one in place. So obvious point, but something to check. Are you as a local authority identified as a permitted user of the framework? A lot of frameworks are drafted very broadly and will specify the categories of users, and it's important to check that. Another point that isn't necessarily appreciated is to check the value of the framework, particularly if you're using a large call-off, to make sure that there is sufficient call-off left. So when the framework is advertised, it will have been advertised with an estimated contract value, and case law has said that if large frameworks are called off after the value of the original framework has been used up, then it may be invalid. There are lots of frameworks about that, and a lot of them will have different terms and conditions. Some will favour the vendor, some will favour the service provider, and some will favour the public authority. So it's important to check whether the contract terms are suitable and reflect a fair allocation of interest for your needs. The final point is check the rules on calling off under a framework. Is it possible to direct award, or do you have to carry out a mini competition? And sometimes there are rules on making changes to the terms and conditions or modifying the pricing. Sometimes it says you can't do that. So you do need to follow the rules very carefully for calling off under a framework agreement. So the next case, I think, the next case is on evaluation.
Sorry, Stephanie, can you mute can you bring your mic up? Thank you.
There, right.
So the next slide.
Right, thank you. So the Bromcom case is a case about evaluation. I'm not going to talk about that in detail, other than to say that this is a case about making sure that you have a moderation process in place, and where you have got individual evaluators, a moderation takes place to ensure that the scores reflect the views of the moderator. What happened here was that instead of carrying out a moderation, the educational establishment just carried out an averaging of scores. And the case law has said that that's not a transparent way of doing it. But anybody who wants more details on that, happy to provide them later. So if we can go on, Romany, please, to the James Waste slide, which I think is a couple of the next slide on. I want to talk about this because this is, again, it's a local authority case and is one of the main cases about substantial modifications that we've had under the procurement law. Again, this is on waste contract. And what happened here is that a number of operators were on a framework for managing waste, and Essex decided that they needed to change the particular landfill sites where waste was taken to. This was aimed at a temporary measure. I'm not quite sure the reason for the change, but because of the way the framework was structured, there was no guarantee of work under it. It meant that James Waste Management was deprived of revenue because of the change in landfill site, whereas one of its competitors did much better. And so what James Waste did is it said that there had been a substantial change to the contract. Now, under the procurement rules, under Regulation 72, you can only make changes to a contract where they are permitted within certain circumstances set out in Regulation 72. And the court looked at the conditions about what was a substantial variation. And on the next slide, I have set out the test. So is there a change in the allocation of risk? Is there a change in scope? Would conditions have allowed for different contractors to have been successful on the framework? And the court said, looking at the changes in the round, they were of the view that the service was essentially the same, but it just took, the place of performance was different, but it was still taking waste to landfill, and the modifications were of a temporary nature. So they felt that there was no substantial modification. Another point, which I think is helpful, is that any claimant wanting to bring claim for substantial modification, the burden of proof is in fact on them and not the public authority to show that there was a substantial modification. So I think that's a useful clarification. So while this case seems to give the benefit of the doubt to public authorities in carrying out changes to the contracts, on the next slide I have put some takeaway points, which is to, where possible, when you're thinking about entering into a contract, always think what the possible variations may be, and if you can, provide for them in clear and specific terms. And if you do need to rely upon Regulation 72 because you get an unforeseen event that happens, follow the rules carefully, look at the overall impact, and try and make sure there's no shift of risk in favour of the contractor. I'm keen to allow time for questions at the end, but I also want to talk briefly about the Procurement Act and where we are on that. So I'm going to skip the next slide and talk about public procurement reform. So where are we now? So the procurement bill is, we're hoping, fairly imminent in terms of receiving royal assent. Its progress has been substantially delayed to the House of Lords and Commons. There are, I think, a couple of final tweaks that are being made to the version before royal assent is given. The latest version of the bill, as far as I can see, is one dated the 24th of February, but you have to track through various Commons and HL amendments, so it's quite difficult reading. I think the outstanding issues are in relation to national security, and there is an outstanding question in relation to debarment and exclusion of suppliers for organ harvesting. So over the summer, there was a consultation on the statutory guidance, and the one that for me was the most interesting of them was the second part of the consultation on transparency notices. So if you've been following the changes in the to the Procurement Act, there is a great focus on transparency notices. I think when I last counted, there was a requirement to publish about 12 transparency notices through the life cycle of a procurement, as opposed to the current 3 notices, so a significant increase in notices, and the consultation sets out all the information that needs to be provided. It also confirms that procurements carried out under the existing rules prior to the implementation of the new Act will be subject to the PCR and not the new provisions, so that provides some certainty. So I've tried to give on the next slide an indication of what to expect when and the time scale. So as I said, we're expecting royal assent finally in the next month or so. I think there's a further consultation due shortly. The procurement reform team have set out the learning and development that is going to be available to public authorities. If you haven't already within your accounts registered for that learning and development, then it's strongly advised to do so. And the publication of the statutory guidance, there's going to be lots of statutory guidance. The Procurement Act is really a framework, and statutory guidance and procurement policy notices and the national procurement policy are all going to form part of the additional guidance that applies to the Procurement Act. Once they've been published, there will be a 6-month notice before the go live date, which is anticipated to be October 2024. So hopefully it won't be pushed back any further. There have been a number of changes. There have been lots of changes to the Procurement Act from the current regime, changes in terminology and definitions. There's been a big increase in record keeping and transparency requirements. There's a fundamental change to the provisions on exclusion and debarment. There's the introduction of more flexible procedures and design your own procedures, which I think will be very helpful. And there's quite a lot of stuff about contract management. So I think I'll be very pleased when the Procurement Act is finally given assent, so we can, we've got some certainty about the final form, so that we can start thinking about training for clients going forward. Just in terms of the definition of a public authority, I'm often asked whether that's been subject to change. On the next slide, there's a definition of the public authority. That's the one that is for other, but in fact it hasn't changed substantially, so nothing particularly to worry about there. I'm just looking to see, right, so on next slide I've got outstanding issues. Right, okay, so the situation with NHS coverage, probably not so relevant for today, but the NHS powers are largely going to be covered under the provider selection regime, which is a new procurement regime that is going to be introduced for healthcare services. That's interesting because there might be some overlap with some local authority healthcare type services as well. I mentioned that there's going to be a lot of delegated powers, as well as the Procurement Act. That has been subject to some criticism, but that's the way it's going to go, and it's the way that Subsidy Control Act has also gone. So what can you do to get ready? I know it seems a long time away, October 24, but it's only a year away and it's going to go very quickly. So on the last slide, I've put some suggestions. And really important to make sure that your contract register is up to date, because that will inform you about what procurements are going to be coming online in the short to medium term. If you are going to be going out to procurement for more than £2 million in any year, which is a high threshold, but is easily met, you will need to publish a pipeline notice giving information about all those forthcoming opportunities. It's worth thinking about those large strategic procurements in the next year, to think about your procurement strategy. And in fact, whether you want to take the flexibility offered by the new regime, for example, for IT services, and if so, whether you need to grant an initial extension, whether you want to make a direct award, because direct awards are going to be much more difficult under the new Act. Just worth thinking about how you're going to manage that process. There are big changes to the way that local authorities will be required to carry out standstill. There'll be a lot more information that is provided about evaluation. So start thinking about what changes you can make to your evaluation process now, so that you get ready to that change. And like everybody, familiar yourself with the Procurement Act. So I'm conscious that I've covered a lot of material in quite a short space of time. If you've got any queries, very happy to take questions now, or happy for you to contact me afterwards. Or equally, if you would like us to do a session for your council on any of these areas, please let us know and we can have a discussion about that. So it is exciting times ahead. I always try and say at the end of my slides, for anybody who has come to these sessions before, transparency is a common theme. So always remember to have audit trails for both subsidy and procurement matters, because that always really helps. So I have got a plea before we go to questions, which is I'd be very interested. We're in the process of putting together our programme for putting out learning and development materials on the Procurement Act, and be very interested if you could just tick how you prefer to get that information, and just tick any that apply. As I say, happy to take any questions. just a quick question out to you. To what extent have you started preparing already for the Procurement Act within your councils? It's interesting to discussion. As I said, I would suggest thinking about preparation as soon as possible. But okay, if nobody has got any questions, then we will finish the session here. Thank you very much for attending.